What's up, guys? Brian Felfel, Law Group PLLC here with your Florida Law Weekly case update. I got 4 cases for you, and it's the day before the 4th of July. So everybody, I hope you have a safe and happy 4th of July. And before that, let's enjoy some cases. So the first one is out of the new 6 DCA, and it's a domestic violence case. Very interesting what the respondent did here. So it's a domestic violence case. Petitioner files a petition for injunction against domestic violence against her live-in boyfriend. They shared an apartment, I think, together. Or they lived at his place, the boyfriend's house. And so after the girlfriend gets exclusive use and possession of the home, boyfriend then goes and turns around and files an eviction action in the county court. So now this is a question of what prevails: a petition for injunction against domestic violence where an order says the petitioner has exclusive use and possession of the home, or an eviction action in county court. And so it's sort of like a, who's got jurisdiction kind of a thing. And so what the appellate court said was the circuit court has superior jurisdiction in this matter. The county court only had jurisdiction under these circumstances to adjudicate whether the boyfriend was entitled to an eviction, but could not actually get a writ of possession that would prevail over the circuit court's order granting exclusive use and possession of the property to the petitioner. So she's able to continue living there pending the resolution of the petition for injunction against domestic violence. So he was not able to kick his girlfriend out of the house just yet. Next case is Mickler versus Iizuka. This is out of the 5th DCA. This has to do with a 57105 motion. And this was very interesting. It was a 57105 motion that got denied at the trial court, and then the person appealed and it got reversed. So what happened here was the parties entered into a marital settlement agreement where they, standard language I'm assuming, where they waived all claims against each other. Now, during the marriage, the husband's parents essentially loaned them money in order to buy a house, and they actually got a real promissory note and a mortgage. And so then the parties, the husband and wife, enter a marital settlement agreement, they get divorced, consent, final judgment, and then after that, the parents try to foreclose on their lien. And so what does the wife do? She files a separate action basically for all these claims, like fraud and all these civil claims essentially against the husband in a separate civil separate civil case. And then at the same time, she filed a motion to vacate the judgment in the family court. But for some reason, she then withdrew her motion to vacate the family court judgment, still proceeded in the civil case. And the trial court basically said, well, I guess they have some sort of a colorable claim to vacate the judgment in the civil case, which they did not, which the wife did not, former wife did not have a basis to vacate the civil judgment the family court judgment in the civil case. And because there was that standard release language, she was essentially pursuing meritless claims by trying to sue him civilly for all these claims in the civil case. And so what the appellate court did was it reversed the 57105 denial. So basically the husband is able to get 57105 fees as long as he can show that the attorney representing the former wife really had no basis to pursue those civil claims against him, made no colorable claim to those. He was really only traveling under the 57105 section that focuses on whether the claims have a legal basis, because the facts really weren't in dispute. So, be very careful in these type of situations. You don't want to try to overextend yourself if you're representing one of these clients and try to file a separate civil action. When you see waiver language in a marital settlement agreement, the court is probably going to enforce that. And if you want to get rid of that language or the marital settlement agreement, you got to file and pursue and obtain an order vacating the consent judgment in the family law case before you're able to get around that waiver language. Next case is Makaver versus Pozuelos. This is out of the 3rd DCA. This is a civil contempt case. Well, actually, who knows if it's a civil contempt case? So basically, it's a contempt case where the court originally noticed it as a civil contempt hearing. Then it became an indirect criminal contempt hearing. But then there was inconsistencies in the oral findings and the actual written judgment of whether it was criminal contempt or civil contempt. Remember, indirect civil contempt is basically coercive in nature, and it's only to make somebody comply with an order. It's sort of like the key to your own cell. You got to have a purge provision type of a thing, only to make you comply with a previous order. And so apparently the trial court overstepped its boundaries, I guess, and kind of treated this as more like a criminal contempt with criminal contempt, you got to follow all these specific procedures, just like any other criminal case where you have to have sort of like an arraignment, and then the person has a right to counsel and all that stuff. So that did not happen. Instead, the sanctions that were awarded included an order that he had to do basically like a job search. Now, I'm a little confused by this ruling because I know that under I believe it's Bowen or Lakashani or one of those contempt cases, civil contempt cases, the court has discretion in a civil contempt case to make sure to order that the obligor who's not paying basically do a job search and report the findings to the applicable authorities, that how many jobs he's applied to, things like that. There's case law that talks exactly about that, civil contempt cases. So it's a little interesting, but the third DCA here basically thought that no, this is because I'm ordering you to do something in sort of like in the nature of like a probation type of order. I'm ordering you to do a job search. They thought that was more criminal in nature, not coercive, but more like to punish somebody. So interesting case. I'm not sure if it's the true right result, in my opinion, because I know under civil contempt you can order somebody to do a job search, and it does seem somewhat coercive in nature to get him to pay, but not according to the third DCA. And at a minimum, there was inconsistencies in the oral findings and the written order, and the procedural posture was not correct, so it got reversed. Next and final case is Frantz versus Crawford-Frantz. This is just a simple case where the court ordered retroactive child support, but they did not account for the time that the parties continued to reside together. During the time that the parties continued to reside together, during that period, you can't get retroactive child support because they were residing together. Statute talks about it exactly. The appellee was trying to argue, well, you can go back to the date of filing, and that's not the law. I think they were getting confused with maybe a modification petition where you can go retroactively back to the date of filing, but for child support under 6130, you can go back to the point where they did not reside together, not to exceed 24 months, I believe it is. So you got to take into account when you're doing the retro, if they're living together during a certain period, you can't count that as retroactive child support. All right, guys. Again, I hope everybody has a wonderful, wonderful, and safe 4th of July. Don't blow each other up, and hope everybody comes back next week safe and sound. Take care, everybody.